What happens if you buy a property with deed restrictions and you don't like them? I've seen people before try to get rid of deed restrictions on their own and fail to do so, and that's because of a common misconception. So let's rewind a little bit. What are deed restrictions? They are restrictions on your use of the property that are placed by a deed and not by a separate recorded instrument. So often, if you've got an HOA or you live in a neighborhood, there will be covenants, conditions, and restrictions recorded that affect the property. But you could also have restrictions placed within the deed itself. For example, let's say I'm conveying a property to someone else and I don't want them to have farm animals. So I, deed over the property and I'll say this property is subject to the following restrictions: no livestock, etc., permitted to be on the property. However you want to word it, as long as it's a legal thing. You can't put illegal restrictions on the property. And so once you've placed those deed restrictions on the property, they run with the property for as long as they are allowed to by law. It is a common misconception that, whenever I convey the property, if I don't want that restriction on anymore, I'll just take it off the deed. People forget that the only person or people or entity that can remove a deeded restriction is the original grantor of the restriction. They hear grantor and think, when I sell the property, I'm the grantor, so I am in charge of whether that restriction stays or not. And unfortunately, that is simply not true. It will be the original grantor who can remove that deeded restriction. So just like in the CC&Rs, you can't unilaterally remove your property from being subject to those. There's the original person who created the document that has to do that. Same thing with a deeded restriction. Where it gets tricky is, at least with CC&Rs, you know where you can go to get, beg for a restriction to be removed. But when you're dealing with the original grantor back in the chain of title, well, for all we know, that could have been placed 60 years ago. And if that original grantor is either as an entity not existing or as a person is deceased, then you have to follow the threads to figure out who is their successor in interest. So if a person is deceased, then their heirs. When that entity was dissolved, where did the ownership, who owned it, who became basically the successor in interest to that entity. And we have seen where someone wanted to get deeded restrictions removed, and they tried to find the original grantor who was deceased. Okay, well, that person had 2 children. They went to find the 2 children who could release the restrictions, both deceased. Okay, well, those people each had, someone had 8 children and someone had, 2 children. All right, you try to find those 10 people. Well, some of them are deceased and some of them are not. So you're basically following the family tree down to try to track down everyone who could conceivably be the successor in interest and ask them to remove the deeded restriction. So the likelihood that you will actually be able to contact all of those people, unfortunately, not super high, but even if you can, then you have to do the convincing. So if you have even one of those people that doesn't want to agree to remove the restriction, whether they actually care or they're just being difficult, then you're going to have a challenging, if not impossible, time removing that deeded restriction. So all of that to say that the person that is in charge of removing deeded restrictions is the original grantor of them. But on the flip side of that, every time you grant property, if you want to add restrictions, you can do that. Let's say you're getting ready to list a property and you want to have deeded restrictions, then you should disclose what those are going to be, because a person is looking at buying the property based on what is existing. So if it's a condition of your contract that the deeded restrictions be placed on the property at closing, that needs to be disclosed to any potential buyers. Otherwise, you may be considered in breach under the North Carolina standard offer to purchase, because you're adding some new title defect or some new title obligation that wasn't disclosed or not existing when you went under contract. So there's a little bonus tip for you if you want to actually grant or place deeded restrictions on property.